Hello everyone and welcome to this module on the Fair Credit Reporting Act, also known as FCRA or Regulation V. Let's begin with an overview of FCRA. Now FCRA is also known as Regulation V, and the Fair Credit Reporting Act or FCRA is a federal law in the United States that regulates the collection, dissemination, and use of consumer credit information by credit reporting agencies. So credit reporting agencies include agencies like Equifax and TransUnion and Experian, and FCRA applies to credit reporting agencies, entities that furnish information to credit reporting agencies, as well as users of consumer credit reports. And the Fair Credit Reporting Act requires that credit reporting agencies provide accurate and complete information about consumers to anyone who has a permissible purpose for obtaining the information, such as a mortgage lender. And we'll talk about what a permissible purpose means in a bit. Now let's talk about access to credit reports. Consumers have the right to access their credit reports and dispute any errors that they find. Now credit reporting agencies must investigate and correct any errors on a consumer's credit report within a reasonable time frame. And FCRA sets limits on how long certain types of information can be included on a consumer's credit report, such as bankruptcies or collections. Now, let's talk about permissible purpose. Now, the Fair Credit Reporting Act requires that users of consumer credit reports have a permissible purpose for obtaining the information and that they obtain the consumer's consent before accessing their credit report. This is very important to understand. So you need permissible purpose as well as the consumer's consent to run a credit report. Now, permissible purpose means that the party accessing the credit information has a legitimate need for the information in connection with a credit transaction, employment, insurance, or another specific purpose allowed by FCRA. For our case, the permissible purpose is obtaining a mortgage. Now, penalties for violating FCRA's permissible purpose rules can include fines, damages, and legal fees. Now let's talk about adverse action. Under the Fair Credit Reporting Act or FCRA, adverse action refers to any action taken by a lender against a consumer based on information in a credit report. Now adverse action can include things like denying credit, offering less favorable credit terms, or charging higher interest rates. These are all examples of adverse action. And it's very important to understand that when an adverse action is taken, the creditor must provide the consumer with an adverse action notice that includes certain information required by the Fair Credit Reporting Act. And the creditor must provide the adverse action notice in writing or electronically, depending on the consumer's preference. Now let's continue our discussion on adverse action. Now, if a consumer believes that the adverse action was taken based on inaccurate or outdated information in their credit report, they can dispute the information with the credit reporting agency and the creditor that took the adverse action. So the Fair Credit Reporting Act also requires that lenders and other creditors provide a copy of the credit report used in an adverse action decision, such as denial of a credit or providing credit under less favorable terms. Now let's talk about adverse items retention timeline. The Fair Credit Reporting Act, or FCRA, sets limits on how long certain types of adverse items can be included on a consumer's credit report. Most adverse items can stay on a consumer's credit report for up to 7 years from the date of the first delinquency, which is typically the date of the first missed payment. Bankruptcies, on the other hand, can stay on a consumer's credit report for up to 10 years from the date of filing. Now, once an adverse item reaches the end of its retention period, it must be removed from the consumer's credit report by the credit reporting agency. And that's very important to understand. Once an adverse item reaches the end of its retention period, it must be removed from the consumer's credit report by the credit reporting agency. Now, as we said, consumers can dispute adverse items on their credit reports. So let's talk about that. Consumers can dispute any inaccurate or outdated adverse items on their credit report with the credit reporting agency and the creditor that reported the information. So consumers can dispute adverse items on their credit reports online, by phone, or by mail. And the credit reporting agency must investigate the dispute within 30 days of receiving it and must provide the consumer with the results of their investigation in writing. And this concludes our module on the Fair Credit Reporting Act, or FCRA.